I want to extend a warm thanks to all of you here in the room in person, and also to all of you who are joining us via the webcast today. Before we officially kick off, I just have a few announcements to make, in particular for those of us in the room. First, it's a reminder with that beep to silence cell phones and any other devices that could disrupt us today. Another reminder, as many of you have just experienced the security at the first level, if you do choose to leave the building for lunch, you'll have to go back through that process to re-enter the building for the afternoon. Finally, restrooms are just out the door. Men's room out the door to the left. Women's room is past the elevators and also to the left. If there happens to be an emergency while we're in the room today, please leave the building orderly and follow the instructions that you'll hear. If we need to remain in the building during an emergency, there'll be announcements over the public announcement system in regards to what we should be doing. If we need to exit the building, for example, if there's a fire, please use the stairs and proceed across the street to 7th and Constitution Avenue. If you notice any suspicious activity when you're in the building or around it today, please notify a security official. Any actions that are taken that attempt or actually do interfere with the conduct of this event or the audience's ability to observe the event, including attempts to speak with speakers while they are engaged in their panels or giving remarks, will not be permitted. If you do engage in such behavior, you will be asked to leave. If you refuse to leave voluntarily, you may be escorted from the building. Finally, FTC commissioners and staff cannot accept documents during the event. Well, this event is the focus of public comments. Those need to be submitted online and cannot be submitted in paper copy to FTC staff or commissioners. Also, as you've noticed and has already begun, the event is being webcast, recorded, and also there will be photographs taken throughout the day. By participating and remaining in the room, you agree that your image and anything you say can be posted indefinitely at ftc.gov, at regulations.gov, or in one of the Commission's publicly available social media sites. As you entered this room, you saw that question cards were available. During the panel discussions today, audience members are invited to provide questions to the panelists. Those are to be written on the comment cards and will be collected before being handed to moderators and repeated by the moderators to the panelists. That is the end of these announcements, and I'm very happy to introduce Randy Treitel for our official opening remarks. Thank you.
Morning, I'm Randy Treitel, Director of the Federal Trade Commission's Office of International Affairs. Well, I'm always told you all the important stuff, but I am delighted to welcome you to the 11th of the FTC's hearings on competition and consumer protection in the 21st century, this hearing co-sponsored by the George Washington University Law School. Welcome to our audience here at the FTC, out in webstream land, and to those who are watching the recording or reading the transcript of the proceedings. This session is a fitting heir to the hearings on which Chairman Simons modeled this, Chairman Potofsky modeled this initiative. 24 years ago, Chairman Potofsky anticipated the major role that globalization and technological change would play in shaping the FTC's priorities and enforcement agenda. This hearing, dedicated to the international aspects of the Commission's missions, reflects the important role that the international dimension of the FTC's competition, consumer protection, and data privacy work are to accomplishing our goals. It wasn't too long ago that I might be asked why the FTC even has an office dedicated to international affairs. Well, I don't get asked those questions anymore, as our stakeholders can see how intertwined the FTC's activities are with global developments. They see how the FTC cooperates deeply with international counterparts on cross-border merger and conduct investigations to ensure consistent outcomes. They see how we use our authority under the U.S. Safe Web Act to work with consumer agencies, regulators, and criminal authorities to shut down foreign-based frauds and return money to victims. They see how we engage in multilateral organizations to promote fair investigations and sound enforcement. We already have had significant international input into several of our hearings. So what are we seeking to accomplish over these 2 days? Well, we have in mind several objectives, one of which is simply to reflect the Commission's keen interest in hearing from our colleagues around the world. But let me focus on two important goals. One is to obtain focused international input on the main topics of these hearings. This hearing session is an opportunity for us to learn from countries in different regions, from different legal, economic, and political systems and stages of development on many of the digital economy and other issues that are the overall focus of these hearings. Second, it's an opportunity for the FTC to hear from the international community on how the Commission is doing its job, where it is succeeding, how it can be improved, and how we can best position the agency to anticipate and deal with future developments. Do we have the right tools? Are we focused on the right issues? Are we advocating our views effectively? Are our current structure and priorities well suited to deal with the issues that are likely to confront us? In this sense, we are following in the footsteps of the FTC at 100 project conducted by Bill Kovacic, our esteemed former commissioner and chairman, from whom you will hear very shortly. To address these issues, we are very fortunate to have with us a stellar faculty hailing from 17 nations on 6 continents. I look forward to hearing from all of our speakers, as well as from all of you and your colleagues, from whom we welcome written comments through May 31st. In my now 20 years back at the Commission, I have seen a continuing deep commitment to support the FTC's international work on the part of successive chairs and commissioners across administrations. That tradition continues today under the leadership of Joe Simons. Reflecting that commitment, Joe is with us now to share some opening thoughts with you. Taking to heart the adage, who needs no introduction, it is now my pleasure and honor to turn the floor over to the Chairman of the Federal Trade Commission, Joe Simons.
Well, good morning, everyone. I think that I was actually one of those people that Randy was talking about early on who wondered why we needed to have an Office of International Affairs. And in fact, because when I was the Bureau Director, I think I probably said that to Randy expressly. Anyway, good morning and welcome to our 2-day exploration of the FTC's role in a changing world. This is the 11th session in our hearings on competition and consumer protection in the 21st century. In previous sessions, we considered the effects of globalization on American consumers and the FTC's mission. Today and tomorrow, we will take a deeper look at how globalization and international developments affect the FTC's enforcement priorities and its policies. The FTC's 1995 hearings, led by then-Chairman Robert Pitofsky, undertook a similar inquiry. Since then, we have seen significant changes to the international landscape. Many jurisdictions have either adopted or substantially updated their competition, consumer protection, and data privacy laws. The number of active enforcement agencies has increased incredibly over this time period. We have seen huge growth in the number of international and regional organizations and networks in which policies are debated and best practices are shared. Today, markets are more interconnected and consumers are more global and mobile. Our task at the FTC is to understand and respond to these changes as we work to promote competition and protect American consumers. Right after I speak today, we have a real treat, and he's sitting right in the first row right there. Our esteemed former chairman, Bill Kovacic, will discuss the history of these international developments. And Bill is one of the world's top experts on this topic, having played a pivotal role in these developments himself, and I'm absolutely confident you will enjoy hearing from him shortly. But before we get to Bill, let me touch on 2 core areas of our international program: enforcement and policy cooperation. Starting today is international enforcement cooperation, today's session. In a quarter century since the Pitofsky hearings, the FTC has been involved in an ever-increasing number of competition and consumer protection matters with an international dimension. We have often cooperated with enforcement agencies outside the U.S., which has resulted in better outcomes for competition and for consumers. That's why, as Randy mentioned, the FTC under successive chairs has focused on developing strong relationships with our counterparts abroad and expanding our cooperation tools. For example, in 2006, Congress enacted the U.S. Safe Web Act. The Act enables effective enforcement cooperation in consumer protection cases by providing the FTC with cross-border enforcement tools in 4 key areas: information sharing, investigative assistance, cross-border jurisdictional authority, and enforcement relationships. We have used this authority in a wide range of cases, from internet pyramid schemes and sweepstakes telemarketing schemes to complex advertising and privacy investigations. The U.S. Safe Web Act has been an incredible success. Under the Act, the FTC has responded to 130 information sharing requests from more than 30 foreign enforcement agencies. We have issued more than 115 civil investigative demands in over 50 investigations on behalf of foreign agencies. These efforts have advanced FTC enforcement and often supported the actions of foreign counterparts in ways that have protected U.S. consumers. For example, in a matter announced this month, the FTC reached a $30 million settlement with the operators of a sweepstakes scam that targeted to a significant degree seniors. We received significant assistance from foreign counterparts, including Canada and the United Kingdom, using our Safe Web authority to share information. The U.S. Safe Web Act is due to sunset again in 2020, and we are urging Congress to reauthorize this important authority, but this time without a sunset provision. Bilateral and multilateral arrangements, including memoranda of understanding, also facilitate cooperation. Today, I am pleased to announce that we are signing such an MOU with the UK Competition and Markets Authority on consumer protection matters. The MOU provides for enhanced information sharing and enforcement cooperation. The MOU moves both agencies towards streamlined sharing of investigative and complaint data, simplifies requests for investigative assistance, and makes it easier to engage in joint consumer protection investigations. At the same time, it provides strong, clear confidentiality and data safeguards for the information that we exchange. I know that CMA Chair Lord Tyree and his Executive Director, Andrea Caselli, join me in committing to work together under the MOU to provide benefits for consumers in both of our countries. Turning to our competition enforcement cooperation, we are literally cooperating daily with our foreign counterparts on mergers and conduct cases under common review. For example, as part of our recent review of the Praxair-Linde merger, the FTC staff cooperated with the staff of 10 foreign competition agencies to analyze the proposed transaction and potential remedies. And we see continued opportunities for expanded antitrust enforcement cooperation going forward. Across our missions, we work closely with foreign counterparts through agency-to-agency networks that facilitate enforcement cooperation and the development of best practices. 2 key examples are the International Competition Network, the ICN, and the International Consumer Protection and Enforcement Network, the ICPEN. The ICN provides 130-plus competition member agencies a specialized venue for maintaining regular contacts and addressing practical enforcement and policy issues. For example, its framework for merger cooperation serves as the basis for many agencies to engage in enforcement cooperation. Similarly, ICPEN gives its 60 consumer protection agency members a forum for exchanging enforcement-related best practices and engaging in practical cooperation. ICPEN members can access econsumer.gov, an 8-language complaint website with an information sharing project sponsored by more than 35 consumer agencies. Today's session will focus on a wide range of tools: statutory authority, best practices, MOUs, and international networks that we use to accomplish our enforcement cooperation. We will also examine cross-border enforcement and policy issues raised by emerging technologies, such as artificial intelligence. Tomorrow, we will turn to policy cooperation. As with enforcement cooperation, we have witnessed a significant expansion in the ways the FTC engages in policy discussions with our counterpart agencies. Our cooperation on policy matters has fostered trust-based relations, open communications between agencies, and served to facilitate effective and predictable enforcement cooperation as well. In addition to regular bilateral discussions with our counterparts, the FTC is proud to play a leading role in multilateral organizations such as the OECD, UNCTAD, and APEC. Through these organizations and the networks I mentioned earlier, the FTC has participated in developing important international best practices, such as the ICN's recommended practices regarding merger notification and review, and the OECD Council recommendation on consumer protection in e-commerce. During tomorrow's hearings, we will turn a critical eye toward the FTC's work in these bodies and discuss the strengths and weaknesses of policy approaches based on soft law. We will also look at the impact of different legal regimes and cultures on policy and enforcement. Our panels will look at other effective ways for agencies to cooperate on policy. Through our technical assistance program, for example, the FTC engages with newer counterpart agencies, sharing our expertise and our experience. The FTC's International Fellows Program, authorized by the Safe Web Act, complements the agency's technical assistance. Over the past 12 years, the FTC has hosted 83 fellows from 34 jurisdictions around the world. As part of these hearings, we intend to explore whether there is more the FTC could and should be doing to promote sound consumer protection, privacy, and competition policy internationally. The final panel will focus on the FTC's international engagement in a changing global world, providing an opportunity for input on the most important enforcement international policy issues that the FTC faces today. Before I conclude, I want to welcome the many agency heads and other representatives from our sister agencies and international organizations who are joining us for these hearings. I also want to thank, of course, our co-sponsor, the George Washington University Competition Law Center. I also would like to recognize the efforts of the staff of the FTC, in particular, the Office of International Affairs, the Office of Policy Planning, the Office of Public Affairs, and the Office of the Executive Director. My fellow commissioners and I are extremely grateful to all the people who have contributed to producing this impressive event, including especially our speakers. Thank you all for attending, and I hope you enjoy the show.
Thank you, Chairman Simons. I now have the pleasure to introduce Bill Kovacic, a director of the Competition Law Center at GW, global competition law professor at GW. In addition, he has enforcement experience. We heard Joe mention your time here at the FTC, both as commissioner and chairman. Bill also serves as a non-executive director at the UK's Competition Markets Authority. Thank you.
Thank you very much, Molly. The GW Law School is enormously grateful to Chairman Simons for the opportunity to co-chair this session, and we're profoundly grateful for the opportunity to begin the program today. To get us started, I want to address three topics. I want to talk about the major ways in which the world competition policy, data protection, and consumer protection have changed since the mid-1990s when Bob Pitofsky convened his famous set of hearings. Second, I'd like to talk about how the FTC has adapted to these changes and to describe its engagement with foreign institutions, including partner agencies around the world. And then third, to think about some possible adjustments to the FTC's tools and practices that might enable it to better address these adjustments going ahead. My perspective today is based on really three activities. First, my work here, as Molly and Chairman Simons mentioned, at the FTC in several earlier incarnations. Second, my work with a number of new competition systems around the world. And third, my experience with the Competition and Markets Authority in the United Kingdom, where I've served as and currently serve as a non-executive director. I don't speak on behalf of the CMA today, but my experience there deeply informs the way in which foreign jurisdictions see the United States and perceive the work of the FTC, and shapes my views about how the FTC's role can be enhanced in the world going ahead. Let's start with the past and look back. Both Randy and Chairman Simons have done this already. I'll just underscore a couple of developments that are certainly extraordinary to anyone of my age, but I think would be extraordinary upon reflection to anyone. First is the adjustment in the number of new systems, and we'll take competition law as an example. In 1995, there were roughly 70 jurisdictions with competition laws. This itself was a dramatic jump from 1989, when there were, depending on how you count them, about 30. Today we have more than 130. That's an extraordinary change in a short period of time. And for those of my age who would have predicted, say when they were finishing school a little while ago, that this would have happened during their lifetimes, that would have been most improbable. A truly astonishing adjustment in the global scheme. Some of the jurisdictions that we regard today as enormously significant because of their activity, for their influence on the global framework, either had extremely weak systems in place in 1995, or they had none at all. Those with nascent or older frameworks that were getting underway include Brazil, India, Mexico, South Africa, South Korea. You can't have a conversation about global competition policy today without accounting for the extraordinary work that these institutions have done. Others had no system at all, most notably China, but the extremely influential system in Asia, Singapore, had no competition law. And we've witnessed a dramatic increase in the number of cross-border alliances, international networks to promote the development and improvement of competition law, to set international standards, to promote the conversation. Simply to take Africa alone, the development of international enforcement bodies like COMESA, the development of soft law networks like the African Competition Forum, simply emblematic of what you see on continent by continent in the exceptional development of new institutions, both for enforcement, but as all of our presenters have said so far today, for policy development. The International Competition Network did not exist in 1995. ICEPEN, which Chairman Simons has mentioned, was underway, but it was a very nascent organization and hadn't attained the level of prominence that it had now. All these things have taken place in the last 25 years. Technological change, which was always present in the system. It's not new to our lives. It's a conceit of the modern age that these things have never happened before. You look at the first decade of the Federal Trade Commission, and it's dealing with upheaval from remarkable new transportation technologies like the automobile, the airplane, communications revolutions brought about by the telephone, the wireless. No, that's a different wireless, but it was called the wireless at that time, thanks to Mr. Marconi. Entertainment revolutions called the moving picture, and soon to be called the talking picture. All of these things take place, and you look at the agenda of the FTC in its first decade, and it's filled with difficult efforts to wrestle with these changes. Those changes were no less remarkable to the citizens of this country at that time than all the changes we see today are to us. But I think we can assert that the absolute and relative rate of technological change is greater now, and that's changed the mix of issues that have come to the top of the agenda. The upheaval in information technology, for example, has lifted the prominence of privacy, a long-standing concern of policymaking in the low-tech days, but now simply perhaps the preeminent regulatory issue of our time, most notably identified by the extraordinary regulatory developments we see around the world, significantly the European Union's adoption of the General Data Protection Regulation in the recent past. Agencies have engaged in a remarkable process of innovation and adjustment in the face of all of these changes. We've seen major restructurings. The agency with which I'm a non-executive director, the Competition and Markets Authority, is a good example. It took two predecessor institutions, combined them into one. Country by country, France, Spain, Portugal, nation after nation have rethought the fundamental structure through which they offer policy, and they've undertaken major upgrades and capabilities. And quite significantly, I think a broad lesson we derive from international experience is that if you're not revisiting the adequacy of your framework every 5 years at a minimum, you're missing a good game. And you're probably not doing your job properly because the array of changes in the world today dictate those changes. If commercial institutions are going to be proficient at innovation and change, the public institutions entrusted with their oversight have to be no less inventive, no less dynamic. And we see in so many areas globally those changes taking place. We also see the adoption, quite important for the FTC, I think, of complex mandates for individual institutions. If we take the 130 plus jurisdictions today that have competition laws, over half of them assign that institution something other than competition law. It's a misnomer to describe them today as competition agency simpliciter. They actually are diversified policy conglomerates. And the most common adjunct to competition law in these jurisdictions is consumer protection. And in the modern world, I think it is a decided advantage and obligation of jurisdictions like the FTC to consider the significance of this multidimensional role of a growing number of agencies and to consider perhaps as a priority how to work in particular with agencies with a similar configuration with the aim of exploiting the full value inherent in that multidimensional mandate and to use that as a basis for rolling out larger programs over time. What's the significance of all of these changes? Well, the complexity of the framework has obviously grown. Many more institutions with mandates that make a difference around the world, and a growing number of jurisdictions which, through their individual initiative, have the capacity to set what amount to global standards. Any single nation in that framework has a keen interest in seeing those standards developed in a way that is good for citizens globally, as well in our own parochial case for the citizens of the United States. The complexity at one level might seem frightening, but it does have a striking advantage. To have so many jurisdictions and in so many instances exceedingly capable people working on trying to solve common problems provides a host of natural experiments from which we might derive conclusions about what might work better in the United States and indeed what the appropriate framework for global oversight might be. In short, a benefit of the complexity of activity, the bewildering activity that we see today, is a remarkable opportunity to measure and assess which kinds of practices might be well adopted on a global basis. And you look at the experience of the US agencies, you notice how in areas such as merger guidelines, the Department of Justice leniency program, the US agencies had no power to force anybody else to adopt these programs. They didn't. By persuasion, they gained broad adoption so that leniency and mandatory merger review with a vocabulary created in the DOJ 1982 guidelines, those are universal features of the way in which we work today, all by persuasion, all by adoption, by no element of compulsion. So this is the framework that brings us to the point. How's the FTC adapted to this? To a striking degree, and I'm not a neutral observer here. I have a pride in the way in which the agency has run, and I'm a fond observer of so many initiatives that it's developed that you can count me as a faintly biased observer here, though always speaking the truth. So a bias that predisposes me to like what the FTC has done here, but of course, a truth seeker that I am, always completely accurate. One thing that we identified that's extremely important here is the development of the Office of International Affairs. One of the most far-sighted things that Debbie Majoris did during her tenure as chair is to foster the creation of that office, to assemble a number of different units within the agency and place them in a single place with Randy Treitel as its head. I don't have perhaps a current accurate count, but my guess is that the total number of people dedicated to that office now exceeds 20 and perhaps 25, roughly in that neighborhood. Ponder that for a moment. In 1979, when I was a young person and I had my first exposure to the Federal Trade Commission as a case handler, the total amount of FTC effort dedicated to international liaison was 1/2 of one work year. That's basically 1/2 of one person's time in 1979. In its place, you now have the extraordinary infrastructure. In a way, it's always made me nervous because I feared a legislative overseer or another might say, why are we doing this? Well, Randy and the chairman have described why we do this. This was a far-sighted decision to build an infrastructure that would be indispensable over time to functioning in this new world of complexity. And in a far-sighted way, Debbie Majoris and her successors gave support to that effort so that at the moment, it's unsurpassed as an institution for doing work in this area. There are a number of international offices that do superb work. I see one of them at the CMA, but when I think of the FTC, I think of the story that I saw in a newspaper during a visit to St. Petersburg where the curator of the Hermitage Museum is asked, do you have the best collection of art in the world? And he hesitates and says, well, it's a hard question to answer. A lot of museums have a good collection. Then he pauses and says, I can assure you of one thing. We are not the second. And when you look at the FTC's OIA team, it is certainly not the second. Another key element that's developed that time, and again, this is truly generated from the staff level up in a thoughtful way and supported by the agency, is SafeWeb. SafeWeb created an indispensable element of the infrastructure that supports international cooperation today, both for the purpose of information sharing and, crucially, it's bilateral information sharing. It's the FTC saying, help us abroad, and we commit ourselves to help you here too. And that promise has been fulfilled. But I'd underscore one other item that Chairman Simons mentioned, and that is the International Fellows Program. One of the best ways to educate others about what happens here and to build the human glue that holds together international relations are exchange programs. And in a remarkable way, the FTC has brought foreign visitors to the FTC and with very few restrictions has allowed them to see everything that takes place here. Attend meetings, go to case handling meetings, watch the development of the individual case and the policy that goes along with it. If you want to build an environment that has the trust that is indispensable to the deeper level of cooperation that will facilitate better work on cases, better policy development, it starts first and foremost with human relationships. Not simply protocols or other ways of doing work. It is the human relationships that cause people to trust each other. This is a long-term growth. This is a decided investment in the future. But that investment in building those relationships through the Fellows Program, among others, is an active faith and commitment in the future that creates the environment in which you ultimately get a better result and the basis for sharing information and cooperating more broadly. Then there are the building of the bilateral relationships, already referred to by Randy and Chairman Simons. The one-on-one engagement and discussion over time that, again, is essential if you're going to have a program that promotes the development of common approaches, understanding of where differences arise, and the gradual progress towards a common result. The contributions to the networks, the ICN, the OECD, UNCTAD, ICEPEN, were it not for the work of the individual agencies, including the FTC, this couldn't possibly have happened. The ICN may be a virtual network, but the work is real. And the only way the work takes place is through human beings committing themselves to do it. I look at the work that Commissioner Boswell and his colleagues at the Bureau in Canada did. Had it not been for Canada providing a virtual secretariat, there would be no ICN over time. And to look, and I'm aware of the dedication of effort at the FTC by its professional staff, by the Office of International Affairs, I will further add that if the Canadian Bureau is one pillar indispensable to the ICN, the FTC is a supporting buttress that was equally important to keeping the ICN working and successful. That was a real and far-sighted commitment. Technical assistance. To sum up, the style. The concern, I think, when Americans go abroad is that they're loud, they're dogmatic, they're doctrinaire. They're occasionally right, but they're never in doubt, so that you worry about exactly what course they're taking and what they have to say. The technical assistance program I've seen going back to its origins, by contrast, thoughtful, sustaining. What's been the role of the advisors? Like the wait staff in the restaurant. We give you a menu. Here are the choices that we have here. Then comes the moment where someone asks, well, what's good? And then there's the opportunity to say, what do you like? What do you want? I can describe for you what might be good. And then to give you a view of what happens. But the listening and the advisory process has been thoughtful and sustaining. I look at the work, for example, done in the Baltics, which I visit on a regular basis to see the 3 members of the EU who have competition agencies there. And I'm struck by how people my age in those agencies come to me and ask me about how well FTC and DOJ staff people that they worked with are doing. I can't give you a rigorous proof for this, but I think a crucial force in the development of so many agencies around the world was the advice and guidance that FTC and DOJ officials provided. That was a far-sighted effort. And a modern example of that is the work that the FTC has done in conjunction with Canada, the European Union, Germany, OECD, and UNCTAD. Footnote, that's a remarkable constellation of common effort that has not always characterized technical assistance, but it happened here. One reason that a first-rate management team and leadership group at the Ukraine Anti-Monopoly Commission has a fighting chance to succeed in exceedingly difficult circumstances is that technical assistance over time. And it's not having someone bring their PowerPoint slides up and run through them, being cautious if they might be to take the name of the previous city at which they gave them off the slide. I saw a presenter in Latin America give a slide that said, "Welcome to Singapore." Not the sort of stale, blow the dust off your notes from the last talk, but hands-on guidance to case handlers about how you actually do the job. And if you purport to talk about merger control and you've never worked on a merger, they should chase you out of the room. And instead, the habit has been in technical assistance to provide the right person to give the right advice at the right moment. And last, I think we've seen as part of the interaction, we've seen better disclosure, and there's been a decided process of learning from abroad. In matters such as Carnival Cruise Lines, I think the FTC, through its engagement with the European Union, came to see that when you close a significant matter, you ought to say why. When you issue a second request, when you issue a subpoena, when you use compulsory process, you ought to explain why you decided not to take further steps. And the habit, not in every case to be sure, but in a growing number of prominent matters, to say why the FTC had decided not to act takes root in this period. And that's a process of very helpful learning. Well, some thoughts about the future. I want to put things in 3 baskets. What the FTC can do on its own, what the FTC can do with the cooperation of other institutions, and last, how the Congress has to help out. First, what can the FTC do on its own? I think a valuable part of these proceedings is the opportunity for the FTC in talking to other institutions around the world to take stock of its own capabilities. It has a scalable mandate that is unique among U.S. institutions and, I would assert, among institutions globally. It has 3 policy domains which increasingly become important in resolving difficult problems: antitrust, consumer protection, and privacy. It has distinctive information gathering tools, and yes, it is an adjudication body as well. Does the United States have a specialized trade regulation court? The answer is it does, and it's in this building. So how can this constellation of activities be applied in a way that offer better policy results? As a starting point, I'd sustain the existing level of commitment to the Office of International Affairs and Things International. It's not just the work of OIA, but it's all of the FTC specialists that can draw in to support projects over time. I would say there's room for better education abroad. I'm somewhat dispirited when I go to international meetings and engage in them to see the level of ignorance I see about what the FTC does and how it operates and works. I think that a fuller effort in international fora to explain that, the speeches, the papers for OECD, the engagement on working groups, would be a way to make this story better known. To make clear, in other words, how the FTC functions and operates as a way of increasing understanding about how policy is made here. So one recommendation is the fuller effort as an educator. I'm struck in discussions about privacy, how a continuing refrain is the US doesn't have a privacy regime. Well, it does. It's not as complete, comprehensive, it does. And in the places where it exists, it can bite you pretty hard if you don't pay attention to it. I think that kind of education is an important focus of what the FTC might do in the future. Second element, better disclosure, more closing statements. My dentist says at certain moments, this is going to hurt a little. This is going to hurt a little. Imagine where we would be in the public debate about dominant firm behavior if the FTC statement in Google, the closing statement, had been more elaborate and coherent. A fuller discussion about what happened and why. And with the inadvertent disclosure of the other memos, might it have been a good idea just to put the whole lot out there? Put them all out there. Read them all, the memos. See what the recommendations were. Yes, you extract what has to be extracted, but you put them out there. You have a much more intelligent debate about the choice and decision that the agency made in that instance. Release them. Better disclosure of broader strategy, using every opportunity to make clear what the overall purpose of the program is and how it's been designed over time. So fuller disclosure. Technical assistance, I would expand the FTC's efforts to focus even more on what I would call the elements of administrative law. One of the most important ingredients of good policy development that I learned in my time at the agency is the critical quality of a good administrative process. A good general counsel's office that handles conflicts of interest, a good mechanism for teaching ethics, a good mechanism for organizing the flow of information through the system. There's not an institution on earth that does not need that infrastructure in order to succeed. And the FTC has an extraordinary reservoir of know-how about how to do those things and do them well. And to build a structure without building them in from the front is a source of failure. And yes, as these proceedings are doing, I would continue my process of evaluation, especially by talking to our foreign counterparts and asking them, how are we doing? Is this working well? What could be better? And to do that on a regular basis. And I think there is the trust and understanding that exists that in the right setting at the right time, you can get informative observations from those individuals. What things require cooperation with other institutions? For this audience and for my colleagues, I turn back to a theme very briefly that concerns me a lot, is coherence between the Department of Justice and the FTC. There should be a routine process by which no head of the institution gives a speech without sharing a text with the other institution. I plead guilty in this respect. I didn't do that when I was here. Tom Barnett, my dear colleague from the Department of Justice, I don't think Tom ever got a speech in advance for me. He certainly didn't get PowerPoints, partly because those are being prepared the night before at the conference site. That's one reason. But even there, I didn't walk them over. I didn't say, Tom, let's have coffee. Let me tell you about what I'm going to say. Good, bad, or indifferent. I didn't do that. How hard would that have been to do? Because a view that I think that persists internationally is, who's speaking for the United States? What is this? 5 members of the Federal Trade Commission, 3 members, the head of the Antitrust Division. What is this constellation of participants, always starting with the caveat, I don't speak for the United States? Well, but of course you do. In some way, it's a basis for inferring what's going on. Would it not be possible for there to be a collective effort by the 2 institutions to formulate an approach to say, what are our themes overseas and how are you going to drive them home? Second element, international cooperation. I think there is a benefit to building on a model that works so well with Canada. And I think about Commissioner Boswell and his colleagues. The extent to which the US-Canada relationship was a prototype for building an effective cross-border approach to consumer protection. All of the work that went in, meeting after meeting, simply first to learn what the other configuration looked like, to learn who did what. How many FTC people knew in advance what the Royal Canadian Mounted Police had to do with this process, or local police, or the Bureau. That was a process of learning. But over years, it became a foundation for an exceedingly well-functioning process of cooperation.
I would take as a starting point the institutions that have a similar configuration, mandate, similar responsibilities. My list, the ACCC in Australia, the CMA in the UK, and a step in that direction, further step taken today, as Joe Simons mentioned, Canada, New Zealand, and Singapore. What do they have in common? Yes, these are all English-speaking peoples. They all have a common program in many respects, many common roots, though variations. I'd put it this way. If you can't test and prototype programs with the government of Canada, our beloved colleagues close by, if you can't do it with the ACCC, with the CMA, with New Zealand, with Singapore, if you can't build a common approach or understanding with those, and they all understand the special considerations that go into managing a multi-dimensional policy mandate, how are you going to do it with the rest of the world? I devote a lot more effort to working with those to build prototypes that can be rolled out and developed more broadly elsewhere. I would work with my partners overseas in more detail on case reconstructions to look at commonly examined files and ask after the fact, what happened? What evidence did we think was important? Why, if we did we come to different results? For international organizations, for international cooperation, I'd think of the example that France and Germany have pioneered in data protection and the digital economy to doing studies together. Might the Bureau in Canada and the FTC be engaged in that kind of common effort? Might the FTC and the ACCC, the CMA, find projects that become useful not simply for advancing the state of knowledge, but building the relationships that make cooperation more effective over time? And last, domestic networks might be enhanced. Striking impression I have from my time abroad is how much different jurisdictions devote by way of effort and personnel to taking discrete elements of their framework and working together with them. The United Kingdom Competition Network, which joins up the CMA with a number of sectoral regulators. The European Competition Network, which the Europeans have used with great effect and success in not just building a common understanding of what's happening, but moving toward the direction of a common policy. Is it not possible for the US to do something similar here on a way that provides more coherence and focus for what it does overseas? Last, Congress, what must it do? It's got to renew SafeWeb with no footnotes attached, unconditional, permanent renewal. New privacy law, comprehensive FTC mandate with no jurisdictional carve-outs. It's impossible to engage effectively internationally if that change doesn't take place. Foreign citizens as FTC employees, I'd reconsider the restriction. It's a global talent pool, and I say day in and day out in all my meetings of the CMA and elsewhere, it's an incredible global talent pool. To not be able to draw from it is simply ignoring an enormously valuable source of personnel. And last, I'd change the Sunshine Act so that the FTC commissioners can consult and discuss in the same way that their counterparts do overseas, at least with respect to the formulation of strategy and policy over time. To sum up, these hearings are a great opportunity for the FTC to assess its international strategy, and importantly, I think, to reinforce the intuition that guided the formation of OIA and the building of the modern program. An agency has a choice every day to consume or invest. By consume, I mean you spend money on cases, you do regulations. Invest means you build the infrastructure that serves over time. John Fingleton at our FTC at 100 hearings said, the problem with this is that the investment in infrastructure does not generate ribbon-cutting opportunities. It does not create the headline, oh, we worked on SafeWeb, thanks. Where's your big tech case? Well, we built a better infrastructure with the International Fellows Program. Yes, 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 yes. The decision to build the infrastructure is important. At the hearings, John said, the investment's important. We probably have to do more of it, but the difficulty is we cannot show in a tangible and concrete way how it has made things better. But I think our experience over time is that it certainly does make things better over time. It's indispensable in this multipolar, complex world that we have. During her campaign, Hillary Clinton had a speech in which she talked about planting trees. And she said, the mark of good public administration is the willingness to plant trees whose shade you will never enjoy. And in many respects, that's what the FTC has done. So good luck in taking care of the trees and in planting more seeds. Thank you.
Thank you, Bill. I now have the pleasure of introducing our next speaker, who we've heard mentioned many times today, Matt Boswell, who is Commissioner of Competition at the Competition Bureau Canada. We're especially looking forward to your remarks for a few reasons and hearing your perspectives. One is similar to the FTC. Your agency has a joint mission, a dual consumer protection and competition mission. You also have a fabulous amount of experience, if I can say so, with enforcement. So you've seen a variety of cases, you've seen the enforcement tools, and we transition now to the lead into our first panel, talking about enforcement cooperation tools. Your experiences with both consumer protection and competition enforcement matters, I think, will be excellent. Thank you.
Thank you very much, Molly, for that kind introduction. It's very difficult to follow former Chairman Kovacic, and I've seen others do it around the world. He's an incredibly knowledgeable, engaging, thoughtful speaker. I actually just want to run out of here and go back to my office and start doing some of the stuff he's recommending, but I'll try and stay on track. Thank you very much to the Federal Trade Commission for inviting me to join today's important discussion. And of course, thanks to all of you for joining us today to talk about competition and consumer protection in the 21st century. So change, as we all know, is inevitable, and it's upon us. The rise of the digital economy in general, and e-commerce in particular, is a truly global phenomenon. More and more, the conduct we investigate is not constrained by borders. And when change happens, the question is not, how do we feel about it? The question is, how will we respond to it? Will we rise to the challenge? Will we seize the opportunities that come with it? These are questions that governments around the world are facing, and how we answer these questions will define our success going forward. We at the Canadian Competition Bureau have a long history, as former Chairman Kovacic pointed out, of cooperation with the FTC, as well as many other international competition authorities. But we must not rest on that foundation. We must continue to build on it and adapt to new realities. During today's digital age, cooperation between international competition authorities is more critical than ever before. We are in the midst of a transformative shift. For example, the giants of the taxi and accommodation industries don't actually own cars or property anymore. Instead, they are using technology to disrupt traditional business models and create digital platforms that connect users quickly and easily. As the Canadian Minister of Innovation, Science and Economic Development has rightly pointed out, the digital economy is the economy. This is the backdrop of competition and consumer protection law enforcement in the 21st century. Digital platforms are creating an economy built on collaboration. And if we want to keep pace, we'll need to continue to collaborate and find better ways to do so. So today I'd like to talk briefly about why international cooperation between authorities is so important. I'll discuss the benefits that it brings us and the tools we use to achieve it. I will end with some examples of cases where cooperation has been critical and we in Canada have benefited tremendously. Plus, without preempting the panel, I will consider a few ways that we might improve in the future. So to get us started, let's consider why it's so important that we cooperate. What are the drivers? The rise of the digital economy in general, and e-commerce in particular, as I've said, is a phenomenon globally. The number of digital buyers worldwide is expected to rise to over 2 billion by next year. That's approximately 1/4 of the world's population buying online. And there are a growing number of jurisdictions with competition laws and authorities and consumer protection laws. As former Chairman Kovacic pointed out, when the International Competition Network first launched in 2001, it only had members from 14 different jurisdictions. Today it has 146 members. We have moved from theoretical discussions of enforcement cooperation to our current reality of regular cooperation between authorities. Now, not surprisingly, for us in Canada, collaboration and cooperation with the U.S. authorities is particularly important. It developed naturally, given our shared border and our close economic and trade ties. The signing of the Canada-United States-Mexico Free Trade Agreement, or CUSMA as we call it in Canada, last year was very important. And once in force, it will serve to further strengthen our commercial relationship and the relationship between the competition and consumer authorities. So, a coordinated approach to the challenges the current digital age raises for competition and consumer protection law is critical for enforcers. And when we do cooperate, there are many benefits for us to reap. Increased detection and deterrence of anti-competitive conduct, efficiencies for both agencies and the business community, the sharing of best practices resulting in more effective investigations and better protection for consumers, and minimized risk and uncertainty for businesses and agencies, because when agencies cooperate around the world, outcomes are more consistent. And at the Bureau, that vital cooperation occurs on a broad spectrum, from extremely formal cooperation to informal avenues of working together. Informally, we exchange public information, theories of harm, and procedural information, such as the timing of investigative steps, and we conduct meetings and staff exchanges. In contrast, formal cooperation can include mutual legal assistance and the sharing of documents, data, and confidential information. For instance, competition policy principles are commonplace in Canada's free trade agreements that are being entered into in the modern day, like CUSMA, I already referred to, and they ensure that the benefits of trade liberalization are not offset by anti-competitive conduct. In criminal cases, mutual legal assistance treaties, or MLATs, are useful formal tools to gather evidence located in foreign jurisdictions. This formal cooperation allows enforcement agencies to share documents, affidavits, lend exhibits, and engage in search and seizure on one another's behalf. The Bureau has used the MLAT process to conduct searches in Canada on behalf of the United States Department of Justice, Antitrust Division, and to obtain important evidence from the United States for the advancement of our cases. Where confidential information is shared outside of MLATs, we often obtain waivers from the parties. But even without waivers, Section 29 of the Canadian Competition Act lets us share confidential information with other agencies for the administration or enforcement of the Competition Act, and of course where we have assurances of confidentiality. The Canada-US Cooperation Agreement, signed in 1995, has served as a high-level framework for our positive cooperative relationship. It sets out how the Bureau, the FTC, and the DOJ Antitrust Division will work together. We also have our Canada-US Positive Comity Agreement, allowing one country to defer to another in cases where conduct in one country creates anti-competitive effects in the other. And more recently, we established our best practices on cooperation in merger investigations, which is a public document that provides guidance to the business and legal community. This was based on years of merger review collaboration between the Bureau and the U.S. authorities. We've put this best practices document to good use. Recently, we worked with the FTC and the European Commission on the Lindy-Praxair transaction, where we obtained multiple remedies. We also worked closely recently with the US DOJ on agricultural transactions, such as Bayer-Monsanto and Dow-DuPont. But one transaction that stands out in my mind for cooperation and collaboration is the Staples Office Depot merger in 2016. It exemplifies the deep and positive cooperation relationship that we have with the FTC. In that case, there was extensive sharing of data and evidence, including the FTC sharing their second request with us. We also seconded a Canadian Department of Justice lawyer to the FTC litigation team and had Bureau officials attend the FTC injunction hearing. As a result of this cooperation, the Bureau and the FTC were able to file simultaneous court challenges to the merger, and the parties ultimately abandoned the transaction. Going forward, I can assure you today that I will encourage Bureau merger staff to seize such opportunities for deep collaboration wherever possible. On the abuse of dominance side, Google comes to mind as a great example of our cooperation as well. The Bureau launched an inquiry in 2013 under our abuse of dominance provisions to investigate Google's conduct related to online search and search advertising as well as display advertising. During the course of our in-depth investigation, we worked with several international counterparts, including the FTC. We concluded, from a Canadian perspective, that Google used anti-competitive clauses in its AdWords application programming interface, terms and conditions. These clauses were intended to exclude rivals and negatively affected advertisers. Google removed the clauses, as many of you would be familiar, and committed to not reintroducing them or similar ones for a period of 5 years. These commitments were similar to those made here in the United States. Being able to readily review facts and evidence related to similar allegations against Google in the U.S. context was of significant value to the Bureau's investigation. On the cartels side, we have our Nishikawa case, which resulted in Canada agreeing to have the United States Department of Justice proceed and take a guilty plea in the auto parts investigation, even though there was an impact in Canada. This demonstrated our commitment to positive comedy between our two nations, and it showed how we can collaborate for efficient, effective outcomes. Let me turn to the area of deceptive marketing. Our legal framework and ability to assist and share information with our foreign counterparts has improved significantly in Canada with the enactment of Canada's anti-spam law, or CASL as we refer to it. CASL brought into force new express provisions allowing the Bureau to use our investigative powers under the Competition Act or the Criminal Code of Canada to assist foreign partners without us having to be conducting our own investigation. It grants these powers with the provision that information will only be used for that investigation or proceeding and will be kept confidential, similar to provisions in the U.S. Safe Web Act. Although I'm unable to get into the details, recently, in response to an FTC request, the Bureau shared information obtained through formal powers with the FTC to assist them in an investigation. Similarly, the U.S. Safe Web Act has been an incredibly valuable tool for gathering information in cross-border deceptive marketing cases. I know, and it's been mentioned several times this morning, the Safe Web Act is up for renewal soon, and I want to say unequivocally and on the record, the Bureau supports that renewal, and we are pleased, incredibly pleased, with how we've been able to use this valuable tool. The Bureau has used Safe Web requests to obtain information relevant to multiple Canadian investigations, as we did with our premium text messaging case, which was litigation against Canada's 3 largest wireless providers for conduct that was deceptive marketing practices. At our request, the FTC applied to the United States District Court for the District of Maryland for an order authorizing the FTC to obtain oral and documentary discovery from a U.S. company, Aegis Mobile. Subsequently, the U.S. District Court ordered Aegis to hand over documents to the FTC, enabling them to then share those records with the Bureau. This was, as I understand it, the first time an American court granted authorization to the FTC to conduct discovery of an American company to assist the Bureau. These events, the tremendous efforts that the FTC went to on behalf of the Canadian Competition Bureau were of incredible assistance to the Bureau in advancing our case, which we were then able to resolve by consent agreements with the 3 largest wireless providers. And it's one of the key reasons that we are so supportive of the renewal of the Safe Web Act. The FTC and the Bureau are also involved in several cross-border regional partnerships related to combating mass marketing fraud, including the Toronto Strategic Partnership, the Alberta Partnership Against Cross-Border Fraud, and the Pacific Partnership Against Cross-Border Fraud. These working relationships, focused on sharing intelligence and cooperating in mass marketing fraud investigations, have frequently led to early collaboration between the Bureau and the FTC. However, communication on cross-border enforcement outside of these partnerships could allow for even broader cooperation between the Bureau and the FTC. More cooperation at the working level and informal discussions on trends, intelligence, opportunities to coordinate investigations, and dialogue early on in the investigative process could make formal information sharing tools even more effective. To that end, we have been participating in regular merger team leader meetings with our U.S. partners since 2011. These team leader meetings were so successful that we've expanded them and have had similar meetings with team leaders on merger review with Brazil, Australia, China, the European Union, and the United Kingdom. We're looking forward to the first abuse of dominance or unilateral conduct team meetings with the FTC and DOJ this coming June. Like the FTC, we also participate in international staff interchanges and host officials from countries around the world. We have had several successful outbound interchanges to the FTC over the years. And of course, we would welcome the opportunity to host a member of the FTC at the Bureau going forward. I might suggest you don't come in the winter. It was actually snowing in Ottawa on Friday. So this networking and the people-to-people linkages such informal cooperation creates builds rapport and eases international cooperation because relationships and trust really do matter. Cooperation among authorities is critical to finding common approaches to tackle global anti-competitive conduct. And through the various tools we have in place, we can continually reap the benefits of working together with our global partners. And together is the key word here. As Henry Ford once said, if everyone is moving forward together, then success takes care of itself. That's true for us too. Strong working relationships are a hallmark of a successful organization in our digital and globalized world, and competition and consumer protection authorities are no exception. Now, let me end by once again thanking the FTC for hosting what I'm sure will be an interesting dialogue over the next 2 days, and I'm really looking forward to joining our panel discussion now. Thank you very much for your attention. Enjoy the hearings.
Thank you, Matt. We're happy to now kick off the first panel discussion, again focused on building enforcement cooperation for the 21st century. I'm Molly Askin, an attorney in the Office of International Affairs, and we're going to co-moderate today with my colleague Lorene Capon, also from the Office of International Affairs. One update to our programming, unfortunately, our planned speaker, Edith Ramirez, is not going to be able to join us today.
Silver lining, that means we are going to absolutely be on time now that we have this great cushion.
That is true. So what I wanted to mention to kick off this panel follows along so many of the themes we've heard this morning. I think in Matt's comments, especially about Praxair and Staples, we heard about the depth of cooperation and how we can use our cooperation enforcement tools to work together and achieve consistent outcomes, but also use those tools to have knowledge transfer between staff at different agencies that makes our enforcement efforts more robust. To give a little bit of light to the breadth of cooperation, while we do work with certain partners at the deep level, we also work with, on many cases, with competition enforcement agencies from many jurisdictions. So just to give a few data points, in the last 8 years, depending on the year, we have cooperated in between 21 and 48 enforcement matters. It's a little bit different each year depending on the cases and the investigations that we're seeing. And in those cases, we have cooperated with between 12 and 21 different competition agencies. And again, those are just the competition cases. So you can see that in certain cases, like Praxair Lindy, we've cooperated with over 10 different competition enforcement agencies, and there's also a range. So as we've seen the number of agencies we've worked with increase, there are a number of sort of repeat players, but in each year we're typically seeing agencies that we're cooperating with for the first time, but again relying on many of the same tools that we're able to use to cooperate with people we work with on a regular basis. So that's a little bit of an idea from the competition side. I think Laureen is now going to share some perspectives from the consumer protection and privacy enforcement side.
Yes, my name is Laureen Capon, and I'm an attorney with the Office of International Affairs, where I focus on consumer protection matters. And for me, the theme of our panel today, and indeed these hearings this week, are "We're Stronger Together." And I wanted to give one case example to illustrate that, and also reinforce the concept that Bill Kavas